Good morning and good afternoon to everybody. My name is Kishore and I'm the event manager with Compliance Key Incorporation and would be your today's host. Thank you everyone for joining in today's live webinar, Compliance with Section 1557 of the Affordable Care Act, Non-discrimination. Today's presenter is Jay Einstein. I will quickly introduce Jay. Jay is currently Compliance Officer for Advanced Medical Imaging Consultants. Mr. Einstein oversees compliance program and serves as Group's Contract Administrator as the Compliance Officer for the Radiology practice. Since 2001, Mr. Einstein has advised physicians, senior management, and board of directors on numerous regulatory compliance issues impacting healthcare operations. Now, before I hand over to Jay, I should inform you that the session would be of 75 minutes and we have Q and A session at the end of the webinar. You can keep sending your questions in the chat window and Jay will answer those questions at the end. We will begin now. Jay, I would request you to please start the presentation.
Okay, thanks Kishore. Again, my name is Jay Einstein. I'm a healthcare regulatory compliance lawyer working currently in Colorado, and I'm going to talk to you today about compliance with Section 1557 of the Affordable Care Act, specific to non-discrimination. Just up front, a couple of housekeeping items. I want to apologize for my voice. I've got a couple sick folks at home, and that's unfortunately got me over the weekend, so I'm doing my best to get through it, and so I may have to periodically take some drinks of water just to make sure I keep my throat in check. So what we're going to do is just talk through compliance with Section 1557. This is something I think a lot of folks got caught off by surprise within the last few weeks. It is something that has been out there, and I think in terms of the effective date of the new rule, I know a lot of folks had kind of gotten caught off guard. So I thought it'd be a topic that'd be worthwhile to talk through and just talk specifically about what the requirements are and how to comply. So what we'll do is we'll talk through an overview of Section 1557 of the Affordable Care Act, and then we'll talk specifically about what the specific compliance requirements are and how to comply with them. And then we'll talk through enforcement of Section 1557 and what that looks like. And then, again, as Kishore had mentioned, I'd be happy to take any questions that you might have at the end. So specific to Section 1557, this came about, it's part of the Affordable Care Act. It technically has been around since 2010 when the Affordable Care Act was passed. It's taken this long for the Office of Civil Rights, or the OCR, to publish their final regulations. And the OCR, I'm sure you're probably well familiar with in the HIPAA world. And so that's the regulatory agency that is responsible for enforcing compliance with Section 1557. But what it is essentially a civil rights provision that was buried within the Affordable Care Act that prohibits discrimination on the grounds of race, color, national origin, sex, age, or disability in certain health programs and activities. When you think about the sort of triple aim within healthcare, access, cost, and quality, this regulation was definitely targeted at the access piece. And so what happened was, the final rule was actually released back in the spring, in May, and then it wasn't published until last summer, and then the effective date was 90 days after the publication date, so that was October 17th. And so this has just been around for the last few weeks, and like I said, I know a lot of folks have kind of gotten caught off guard with it. And the good news is there are some resources that are out there to help you. Aside from this particular webinar, I'm going to talk through some of the tools and resources that are available to you and kind of show you where to go to get those in the hopes that it helps you. So here is the general rule of non-discrimination under Section 1557, and I included the site there for you. Many of the provisions that are part of this final rule already exist in other federal non-discrimination rules, such as Section 504 of the Rehabilitation Act of 1973, or the Civil Rights Act of 1964, the Age Discrimination Act, or the Americans with Disabilities Act. So many of these laws have obviously been around for a long time, and they're going to apply to your organization as it is an employer. But what is different here is Section 1557 is taking things a step further, and they're going to apply it, the same non-discrimination rules, they're going to apply those to health care programs and activities. So that's what's going on with this particular section. In terms of applicability, I highlighted it on the previous slide, and I've got a couple other key terms highlighted in red here that we're going to kind of talk through. But generally speaking, it's going to be targeted at all healthcare programs or activities that are going to be the recipient of federal financial assistance, as well as programs that are going to be administered by the state or federal government that are healthcare program related or healthcare programs or activities. So let's talk through that a little bit more, just to give a little more clarity, because obviously I understand that's definitely some vague terminology. The first one I wanted to talk through is health program or activity, and what the heck does that mean? Under the regulation, it means the provision or administration of health-related services, health-related insurance coverage, or the provision of assistance to individuals in obtaining health-related services or health-related coverage. So again, you may be thinking, okay, great, well, that's some more vague terminology, Jay. I understand that. It's definitely was designed to be very broad, and so let's drill down into some more specifics to give you an idea of what exactly the OCR is talking about. Specifically, I listed some examples there: hospitals, clinics, group health plans, health insurance companies, physician practices, community health centers, nursing facilities, and then residential or community-based treatment centers. When they have this nice, lovely, catch-all term, or similar entities. So by and large, these are the groups that the OCR was intending to target. You know, and I can tell you from reading through the preamble to this final rule, the intent was really to try and capture as many participants within the healthcare system in the United States as they could. Shifting gears and talking through another specific term, federal financial assistance. I won't read through it, but you have the language up there, and you've got a cite to the actual regulations. Really, when you break this down, it's going to primarily relate to payments that you may receive from Medicare, different parts of Medicare, and we're going to talk about that here in a second. Medicaid payments, or other types of financial federal assistance, whether it's cash or it's in kind, such as real estate. So again, in terms of some very specific examples, these are going to be your most common ones. If you're the recipient of Medicare Part A, Medicare Part C, Medicare Part D, state Medicaid, federal grants, loans, or subsidies. So, for example, if you're the recipient of grant money related to clinical research studies, or maybe your organization has a residency program or other types of federal programs where you might receive federal money, those would bring you within Section 1557. Tax credits, cost-sharing subsidies under the Affordable Care Act. Meaningful use payments, that's going to catch a lot of folks as well. And then also other types of funding, such as CMS demonstration projects. One thing to specifically note, to be consistent with other federal regulations, they did carve out an exception here for Medicare Part B payments. So if you only receive Medicare Part B, and that's it, you don't receive any other federal, or you don't receive federal financial assistance from any of these other sources I've listed here, then Section 1557 will not apply to you. But if you do, then it will apply to you. Just to further define what the OCR is referring to when they're talking about a health program or activity, It's also going to include all health programs or activities administered under Title I of the Affordable Care Act, which is essentially the health insurance marketplaces in the states. Excuse me. And then also where an entity is principally engaged in health services or coverage, it's going to basically extend to all of that entity's operations. So I put up an example there of, let's say, for example, you've got a hospital. It's going to obviously apply to all the clinical departments. So those would be the activities you would principally think about would be, that particular type of facility would be engaged in, the clinical stuff. But then also things like the gift shop or the cafeteria or some of those non-clinically related departments. It's going to pull them in as well. So really kind of the bottom line is, if your organization receives any kind of financial assistance from the federal government, most likely Section 1557 is going to apply to you. And so now we've kind of talked through sort of the general rule and who it applies to. What I'd like to do is just shift gears and talk through some of the specific requirements that need to be met. This first slide I wanted to include so that I'm not sure if you're like me, but I like checklists. And so this is sort of the one slide I wanted to throw in there that could help you in terms of your checklist. We're going to talk through each of these and what some of these things mean and how you interpret some of these requirements. But here essentially is your checklist. The one thing I would add is an asterisk, and I apologize, I should have highlighted it here, is conducting staff training. It is actually technically not required, but I think in terms of your own organization's defense for complying with Section 1557, it would be a good thing to make sure that you conduct your staff training. And there are some different ways you can go about doing that. We'll kind of talk through that a little bit later. So let's talk through each of these. The first one is ensuring meaningful access to individuals with limited English proficiency, or LEP. The rule here is covered entities must take reasonable steps to provide meaningful access to limited English proficiency individuals. So a couple things to kind of talk through, and I've highlighted them there. We've got sort of some vague gray terminology there with reasonable steps and meaningful access. It's going to mean things like providing language assistance services, whether it's oral interpretation or written translation. And basically what the OCR was getting at with this particular requirement is that they want to make sure that you're providing language assistance services so that your communications with individuals that may be LEP are going to be as effective as communications with others who are not LEP, so that you're essentially treating everybody fairly and in a non-discriminatory way. Reasonable steps and meaningful access is obviously going to mean different things to different organizations based on the types of services you provide. The size of your organization and the potential resources you may have available to comply with this particular requirement. So what I wanted to do is just kind of talk through some examples and kind of drill into the specifics on this particular requirement. So for language assistance services, covered entities do have some flexibility, and we'll talk through some more specific examples here in a sec, but essentially what the OCR is expecting is that when you're providing language assistance services, you have to make sure that you're providing them free of charge to the individual. It has to be something that's accurate and timely, and you have to protect the privacy and the independence of the particular individual. So like I said, there is some fluidity with this in terms of how you're going to comply. So let's walk through some kind of specific examples here. I put these in kind of a do and don't type situation. So the first thing is just make sure that you're providing oral interpretation. You're making sure that it's available for free when it's a reasonable step to do so. So what is a reasonable step? I included some examples there, your most common ones. You can certainly use qualified bilingual staff. The key there is making sure that they're qualified. And I'll talk about that in a sec here. Using in-person interpreters or phone interpretation or remote services, and you can do that all through contracted services. There are companies out there that do provide language assistance for foreign languages as well as sign language interpretation. So those are companies that you could look into contracting if it is financially reasonable for you to do that. But the most cost-effective one obviously is going to be bilingual staff if you've got staff on hand that are qualified that can do interpretation. In terms of qualified, you just need to make sure that you have an independent and objective analysis of those particular staff members to make sure that they are qualified to provide accurate and timely interpretation. There's specific testing and specific certifications that you can look towards to help demonstrate that they're going to be qualified. Language assistance companies, they will, in addition to providing their own interpreters, they will also help certify others to make sure that they're qualified. So that's another service you can look into with these particular companies. The other one is, just make sure that you're providing written interpretation and it's available for free, again, when it's a reasonable step to do so. So what are some reasonable steps? Again, the OCR has kind of given you kind of a broad range of possibilities, either providing written translation of an entire document, written translation of a short description of a document, or making oral interpretation of a document available. So a big question that you're going to have to grapple with this specifically is which particular documents. Every organization is unfortunately going to have to answer that for themselves, but I can give you, just some ideas that, you're going to want to make sure that you drill into any types of documents that you have where a patient or somebody is coming in and signing off on, if it's an informed consent form, if it's a patient's rights form, or other types of rights that you're making sure that they're available to them, making sure they're aware of whatever their rights and benefits are, and if there are other things that you're requiring them to sign off on. At the end of the day, they need to make sure that they're making an informed decision, and the only way they can make an informed decision is if they understand the material. So if you're running into documents like that, those are the ones you want to make sure that you have translation of. If it is, other internal type communications within your organization that is not typically available to the public, those are obviously documents that you don't necessarily need to make sure that they're translated. Then specifically looking at some don'ts, there are some specific things I did want to talk through. And that is, one is you can't require them to bring their own interpreter or require them to have an accompanying adult to serve as the interpreter, or require a minor child to serve as the interpreter, or rely on an interpreter as the individual prefers if there are other competency or confidentiality concerns, or use low-quality video remote interpreting services. These are specific examples that are included within the preamble to the final rule. So you want to make sure that you're not doing these things. And then I listed the exceptions up there. So this is to sort of balance out this conversation, which is to say that if the patient walks in and they have an accompanying adult that they intend to have serving as their interpreter, if the patient requests that they use that interpreter, that's okay. You just can't require it, but if they request it, then you can certainly accommodate that request. I would just add to make sure that you've got documented somewhere in your records that the patient requested it and that you facilitated the request. The other one is if it's allowed, it's allowed if it's in some type of emergent type situation. So, so those are sort of the do's and don'ts with regards to making sure that you're ensuring meaningful access to individuals with limited English proficiency. So big picture, at the end of the day, covered entities do have flexibility to determine, how they're going to provide meaningful access. And there are several factors I included here that the OCR is going to take into consideration when they're gauging your particular compliance with Section 1557. The length or complexity of the communication, prevalence of the language, in your particular market or your particular community. What's the frequency that your particular organization encounters this type of language? Did you weigh the patient's preferences, and then what are the costs associated with the language assistance, and did you have, or do you have a language access plan? So I want to kind of hit on those last 2 bullet points. Obviously, complying with this is going to mean different things to different types of organizations and what resources they're going to have available. I've worked in the past for large health systems consisting of a couple 100,000 employees that would have had a lot of financial resources available to ensure compliance with this. I currently work with a physician practice right now, very limited resources. So when you're looking to, one of the things, you do is if you have, again, if you're a smaller organization, you have staff on hand that are qualified that can provide interpretation. That's certainly something that you can do. It's permitted. And then the other thing you might want to look into is just contracts with these language assistance services companies. And really kind of take a look at what ones are available in your particular market. There are some that are going to have sort of a monthly retainer type fee that's going to be a little bit more costly. If you're a larger organization, it may be pretty easy to meet that monthly retainer. There's going to be other organizations a lot smaller, and it may be a low volume type issue that comes up, and that's similar to the organization I currently work for. So we have contracts with companies that essentially we pay on a per-click basis. So if somebody comes in and requests an interpreter, we then make a phone call and we engage that particular company to provide us an interpreter. It's only at that point that we actually get charged for it. So those are something that's a little bit more financially reasonable and is available to you. And so those are the things that if you're a small organization, you're going to want to look for and see if you can have access to. Excuse me. And then language access plan. So I have this as a separate slide, and I kind of wanted to talk through this. Now, these are not actually required by Section 1557, but similar to compliance programs, if your organization is subject to an audit or investigation and the OCR ends up coming in, they will look favorably upon you if you have a language access plan in place. Essentially what it is, it's going to be just a document that you could produce that's going to identify, how you are going to determine somebody's primary language, engaging certain companies or translation services to be available or using qualified staff, how are you going to provide interpretation services, identifying any other types of language assistance that might be available, whether it is for somebody that's visually impaired or hearing impaired, and then identifying documents, again, that are going to need to be translated. So I talked about this earlier, but, things like your informed consent documents and your patient's rights documents and those types of things. So that essentially is what is a language access plan. I included a site up here, and I apologize. I didn't really have a clean screenshot to show you, but here is basically a sample language access plan that you can find on the DHHS website. The link is there. You could probably just Google it, and it'll pull right up. Admittedly, this is, when you open it up, it's a very broad document. So it may be a little bit overly broad for your particular needs, but at least it would give you a starting point, and then you could trim it down to fit your particular organization and your resources. But it's going to help you with some of those particular requirements for identifying and how you're going to respond to those with limited English proficiency and other language needs. Okay, so next I want to shift gears and talk through another requirement that is under Section 1557, and that is posted notices and then posted taglines. And these are essentially going to be considered part of your overall compliance with ensuring meaningful access. But I wanted to kind of pull them out separately because there's some specific requirements, and I wanted to kind of talk through what these documents look like and where you can go to get the information. So here is a copy of a posted notice. I don't know if you can see that or not, but a couple things just to talk through this. what this notice is essentially the notice that your organization stating that they don't discriminate based on race, color, national origin, age, disability, or sex in compliance with the federal civil rights laws. This particular notice needs to be posted in English. I'll talk a little bit later about where we need to post these, but for now, just note that they need to be posted in English. And essentially what this notice covers is, not only that statement that you're going to comply, but then also, how somebody can file a grievance, who's the designated coordinator for disability or non-discrimination types of claims, or discrimination types of claims, I should say. I apologize. And where to go to get information and kind of how your compliance program functions with regards to a specific requirement. This document is in a Word format. I'll show you where to go to get it here in a second. But you can see how it's on the DHHS website, but you can see how basically I've got them highlighted, name of covered entity. Complying with this actual part is really actually not that time consuming because the OCR has actually done a lot of work for you in coming up with the actual text of the notice. You can, of course, manipulate a little bit and do something different to fit your organization, but this is essentially going to give you a starting point for the types of information they're expecting you to include in your notice. And then here's the second page, and it talks about who designated who the coordinator is and where to file a complaint if it's with you or if it's with your organization or if it's to the federal government. So in terms of where to go to find these notices, hopefully that circle will show up there, but basically just go out. There's this whole section 1557 website on the OCR website where a lot of this information is. And you can go out there and find it, and there's a copy there. It's in a PDF or in a docs format, and I would just advise to pull up the docs version, save it to your local computer, and then plug in your organization's information and your contact information or whoever the coordinator is going to be. But that's where you're going to find the information on the notices. The other requirement is the taglines, or what the OCR is calling a tagline. I'll show you those here in a second, but what you have to do is post these taglines in your top 15 non-English speaking languages in your particular state. And again, here's a copy of what the tagline looks like. Essentially, we may have some Spanish-speaking attendees, but essentially this particular tagline is just stating that the organization is not going to discriminate on the basis of race, color, national origin, age, disability, or sex. And they have versions, and then you have your contact information to include there. And so what you need to do, first of all, is figure out what your top 15 languages are going to be. And there is a link right here that is highlighted. It's under the FAQ page, and when you click on it, it's going to pull up this document. Now, you probably can't read that, and I wasn't really intending for you to read that. I just wanted to give you kind of a visual so you could understand, when you click on this link, it's kind of buried, but it's actually right here where it says PDF. It's going to pull up this document, and this basically is going to be every state in Puerto Rico, and it's going to include the top 15 languages in your particular state. So find that document, pull it up, and then once you've done that, you're going to want to go back out to the Section 1557 site. Oops. And I apologize, that should, excuse me. That circle should actually be up just a little bit, but translated resources for covered entities, that's actually what you're going to click on. And when you click on that, it's going to pull this page up, and this may look familiar because I had it pulled up earlier for the notices, which are right here. But down below, starting right here, these are all the taglines. And again, they're in a PDF version, they're in a docs version. And if you were on this page, you would scroll down and it would have all these different languages that should cover your top 15. And so then you would just pull those up in a docs version and then just save them to your computer and then just add in your phone number and then do that for your top 15. And so that's the notices and the taglines and kind of where you go to get those. So logical question you probably have already been asking yourself is, where do I post these? So, excuse me, there's 3 different places essentially they need to be posted. The first one is on your website if you have a website and on the home page. Also physical location that's going to be prominent or conspicuous to the public, and then significant publications or significant communications. And just to kind of talk through this for a sec, so the website, you know, you can work with your IT folks or whoever oversees your website administration, but I can tell you, I think what a lot of organizations do is they put this down at the bottom near their notice of privacy practices. It just seems kind of like a logical place. You can include a hyperlink, non-discrimination, and then somebody would click on that, and then from there, it's kind of up to you how you want to lay the information out. Some organizations, what I've seen them do is actually have hyperlinks to the top 15 taglines in the notice and everything, you know, and it's obviously those are additional pages that are going to have to be built out. But I've also seen organizations that have just basically taken the notice and then the top 15 taglines and put them all in one single PDF, and then when you click on that non-discrimination link on the home page, it pulls that PDF and all the information is there in one spot. So it's kind of up to you how you want to do that. And you could probably do some Google searches for some other organizations and kind of get some ideas of how they've posted it. Physical location, again, that's going to be prominent, conspicuous. This is going to be dependent upon your organization and how you're, you know, how you're laid out. Again, I work for a physician practice, but the physician practice I work for, all of our physicians we're hospital-based, so they're all located at the hospitals. We don't have any physicians actually here in the building. We're just in a corporate office, and so the only patient interactions we have is for individuals coming in to pay a bill. And so we have patient consultation rooms where they would go in to pay bills, and that was the logical place for us to include this posting because that is the most prominent, conspicuous place for the public. So, but if you are, you know, if you provide direct patient care and you've got registration staff, it might be that you need to post it there. Or again, if you've got your notice of privacy practices or wherever you're posting those existing requirements, it may make sense to include this along with that information. So hopefully that helps. Sorry, the throat got a little dry again. Now, the last one, significant publications and significant communications. I had to take a drink of water for this because this is likely going to be the area you are going to struggle with, and you, like the rest of us. There is not a ton of guidance out there in terms of what the OCR means by this. Very broad terminology, very broad language. And I'm going to include it here in the next page. This is actually from the Federal Register. I included the site up there if you want to go look for it for yourself. But essentially they intend the scope to be very broad, and so they put in a couple of examples there to include not only documents intended for the public, such as outreach, education, or marketing materials, but also written notices requiring a response from an individual and written notices to an individual, such as those pertaining to rights or benefits. So again, if you've got patients' rights, patients' benefits, information like that you're already disseminating, you may need to include those, the notice and taglines there. But it also raises some questions about things like billing statements or notice of privacy practices and some of these other notices that organizations have, and do we need to include those, you know, or other marketing type materials. So I unfortunately don't have a good answer for you. Like I said, it's going to be kind of organization specific. You're just going to have to determine for yourselves, you know, what you want to include the notice and taglines on. I think a good guiding light or a good guidepost, I guess I should say, is what I've included there in the red about, you know, if it's something you're sending out that's requiring a response from somebody else, that may be a good marker for whether or not you need to include the notices and taglines. A couple comments on the notices and taglines to make is the OCR has given a little bit of leeway in a couple particular areas. One is if you have a brochure or a postcard or something that's physically going to be a smaller type of document and there just is not the room to put a notice and these taglines in 15 languages, they will let you do an abbreviated version of that, which is basically just including the general statement that your organization is not going to discriminate on the basis of you know, age, race, national origin, sex, or disability, et cetera. And then you can include the taglines in just 2 of your top non-English taglines for your particular state. Excuse me. And then the other thing is, if you currently have a stock of these marketing materials or other information that you've already sent to printers and you've already expended money towards producing, they will allow you to run out of that stock before you would need to include this information on your other publications or communications. So, excuse me, that is something I want to particularly point out. Okay, just shifting gears, separate from the requirements that we've been talking about related to language access, there's also provisions within Section 1557 that are going to relate specifically to sex-based and disability-based discrimination. So I did want to pull those out and just specifically talk through those. Here is essentially the general statement of non-discrimination. And again, I included the site there for you so that you've got it. And specifically to sex discrimination, I'm not going to read through what I've got listed up there. You've got the site there. I just wanted to make sure that it was included for you, but I just kind of wanted to summarize this particular slide and the language. So essentially, it's, you know, covered entities are going to be prohibited from discriminating on the basis of sex. So it could include an individual sex, it could be pregnancy, it could be sex stereotyping, or it could be gender identity, just for some more common examples. So give you a couple of specific examples. You know, a covered entity is going to have to provide equal access to their healthcare facilities and services, insurance, or other health programs without regard to sex, depending on what types of services that you provide. So obviously the insurance is going to be more related to managed care providers. And then specific to gender identity, just, you know, a common example would be, or a couple of them would be, you wouldn't be able to deny a transgender male a pap smear or a transgender female a prostate exam under this particular regulation. So again, very broad. A fine point on this is if your organization has sex-specific programs, they may be permissible if you can demonstrate that there's what's called an exceedingly permissive justification. And an example that they gave in the regulations was sex-specific clinical trials. In those particular situations, it may be that you have to actually discriminate based on sex. So sex discrimination, you know, there could be really a whole nother webinar just specific to this topic and, you know, different types of scenarios that might be out there and how you would kind of work through those scenarios. And so It'd be beyond today's webinar to go into those, but what I would encourage you to do is to go through the Federal Register. I included on some of these previous slides. It was essentially what was published back last July. They are painful to read through if you have never read through one, but they can be a wealth of information. And if you deal in this particular area where you may come into a situation that you may need to try and figure out how you're going to navigate, I would encourage you to read through the Federal Register specific to the sections talking about sex-based discrimination, because there were a lot of folks that commented on how this rule is going to apply, or they said, we don't agree with this is going to cause us problems here, or it's going to cause us problems there. And then the OCR responded and either said, yeah, you're right, we're going to modify the final rule a little bit here, or they said, no, we don't agree with that, we're going to stick with what we have, basically. So, but it is a wealth of information to read through, because it will give you an idea of what the OCR is thinking and how they're going to interpret these particular rules related to specific types of scenarios. So that might be something you want to take a look into. And then next is disability discrimination. Covered entities shall take appropriate steps to ensure that communications with individuals with disabilities are as effective as communications with others in health programs and activities. So again, very similar language to the sections about limited English proficiency individuals, and just making sure that these communications are going to be the same as if somebody wasn't LEP or if somebody did not have a particular disability. And in particular, it's going to relate to visually impaired or hearing impaired. And so, again, you have to provide free of charge auxiliary aids or services such as qualified interpreters, sign language, captioning. Some of your information you may need to provide large print materials. TTY lines might be something that you may want to look into, seeing if you can have that available if you don't already, or video remote interpreting services. And similar to the other areas, excuse me, that we talked through in the language access services area, there should be a range of options available to you, some of which are going to cost more, some of which will cost less. So you just need to explore what options you have available to you that's going to be cost effective. But the government is not expecting you to engage in any kind of financial hardship. And so, you know, you would have to provide these things for free, again, unless you can demonstrate that just with any of these options, it's still going to be financially too burdensome. If there's a way you can demonstrate that, then it's a way you might be able to get out from under complying with this particular requirement. But I am, just from my experience, I know that there are a range of options out there, some of which are more cost-effective than others and can appeal to smaller types of organizations. One of the things that you want to kind of consider when you're taking this into account in terms of providing these types of services is sort of what is the patient comfort level going to be and what are the needs of the patient population in your particular market or your particular community or state. Those are things that will probably help you in terms of defining how you're going to comply with this particular requirement. Okay, shifting gears a little bit. So another requirement is just making sure that you have a designated coordinator to oversee your compliance with Section 1557, and then a process for resolving grievances if there is a complaint that comes forward alleging noncompliance. So let's talk through that. There's the regulation language. This is going to be triggered only for entities that are going to employ 15 or more people. So that's one thing to keep in mind. And you just have to designate at least one employee to coordinate efforts to comply and carry out the responsibilities under Section 1557. So you'd have to determine, who in your organization, if this does apply to you, who in your organization is going to make the most sense to carry out this particular responsibility. It may be that in your organization, HR might be a logical fit because they are going to already a lot of times be responsible, or they certainly are going to be aware of the other federal civil rights provisions that's going to be applicable to your organization as an employer, ADA or Title VI. So that might be a logical person, or it could be you as compliance officer. I can tell you in our organization, I'm the designated coordinator for us. We do have over 15 employees. So this person is me. So, and I'm not sure if you caught it earlier when we were talking about the notices, but once you designate a coordinator, you just have to make sure that you include that information on your notice along with title and phone numbers so that individuals would know who to contact if there was a concern that came up. And then generally speaking, this particular coordinator is going to basically be overseeing your overall compliance with Section 1557 and responding to or investigating any complaints of noncompliance. And that's sort of the second piece to this, which is adopting grievance procedures. And again, I included the language up there. There is a sample grievance plan. I apologize, I didn't include it here, but if you go out on the OCR website, there is actually a sample grievance procedure that you can find on the OCR's website to help you. And it's actually very similar to the notices, where all you really need to do is just plug in your organization's name and then whoever is going to be the designated coordinator. But just a couple of comments about the grievance procedures. And I've highlighted a couple of the words there, the due process standards and the prompt and equitable resolution of grievances. Those are going to be the sort of guideposts that you're going to need to use when you're drafting these particular procedures. And so a couple of things with that. One is, just making sure that these procedures are going to spell out, where can somebody file a grievance. And this also should be part of the notice, as you may have seen earlier. There's language in there about where people can go to file a grievance, if it's internally with you as the coordinator, or if they want to contact the federal government through the Department of Health and Human Services. And then you need to include, and this is more of the due process piece, you need to make sure that you include your time frames to give them essentially an opportunity to be heard. So the recommended time frame is 60 days. Give them 60 days to file a complaint. There should be a requirement that they file that complaint in writing. And then there should be some language within these procedures that's going to talk about the investigation process and what the time frames are for that. Typically, I think 30 days to close out a particular issue unless there's some type of extenuating circumstances is a reasonable time frame. And then also, and that's sort of, again, I apologize, that actually gets to the prompt and equitable resolution piece of it. But then back to the due process part, the other thing you need to make sure you include in this is a tiered system in terms of if somebody's going to make a complaint or file a grievance with you and you're the compliance coordinator for Section 1557 and you're the person responsible for doing the investigation, and you're going to be the person responsible for ultimately communicating back to the individual what the findings are of your investigation, you need to make sure that you give that individual another layer essentially to appeal that to within your organization. And again, you're going to have to figure that out for your organization and your structure, what makes the most sense. But it should be somebody higher up than you. So that could be a CEO, that could be somebody within senior level management, could be a chief administrative officer or chief operating officer, or it could be a board of directors. But you just want to make sure you have another higher level up that person can then appeal to. And that gets to making sure that these due process standards are in place. I mentioned this earlier. So the grievance materials, it's right there. I apologize, that line kind of goes through it, but if right in here, if you look at that, you'll see that there's a PDF that you can click on, and it'll pull up the grievance procedures. And there's a copy of what the actual grievance procedures are that they've made available for you. Looks somewhat similar to the notice that we went over earlier, and I don't have it highlighted, but like right here is name of covered entity. So there's a lot of these spots in here where you basically are just going to plug and play your particular organization's information. Okay, shifting gears to staff training. Sorry, I had to take a drink there. This is something, again, I think I'd mentioned this earlier, but it is not technically a requirement under Section 1557, but I would encourage you to do this because it will help go towards demonstrating your compliance. Not with the particular organization I'm at currently, but organizations I've worked at in the past. I have been involved in situations where there were HIPAA-related complaints that were made to the OCR. Thankfully, there were things that were resolved in our favor. There were situations where somebody had made a complaint. We did an investigation, and then the person, unfortunately, was not happy with the result. So they went and complained to the OCR, and then the OCR called me, and then I had to turn over documentation related to the investigation that we did and some of the work that I've done. I've had that come up a few times in other organizations I've worked at where I've had these interactions with the OCR. And so I wanted to bring that up specifically because I can tell you documentation is something, if you've never gone through an OCR investigation or audit, they are very big on. Also, staff training, they are very, very big on. I have had to turn over copies of PowerPoint presentations. I've had to turn over attestations that employees had to sign that they read and understood our policies, attendance sheets for staff trainings that we had conducted, or if it was something where instead of a staff training, maybe part of the corrective action is at the outcome of that investigation was that we were going to attend a department meeting and we were going to retrain that department on HIPAA. We had to turn over copies of the agenda from those meetings to demonstrate that we were there and we conducted that training. So again, falls in that sort of that overall theory of, you know, if it's not documented, it didn't happen. But just keep that in mind. Staff training is something you definitely want to make sure you've got documentation of because they will likely ask you for that information. So again, not a requirement here, but there are materials that are available to you, again, on the OCR site, and I included them there, just the training materials. And yeah, right there. So it's highlighted. So training materials, it's right there again. You go in there, and then there is, actually, I think that was the previous. Yeah, so actually when you click on this, it takes you to this screen. And there's a presenter's guide, and then there's a slide deck. So if you want to do that, you can certainly pull off their PDF, and you can send it out to your staff and consider that your training, or you could develop your own PowerPoint, or you could do an email training, or you know, what makes the most sense with your education and how you do that in your organization. But there are materials available again for you, so you know, at least they've helped you out with cutting down the amount of time to help produce some of the content. Oh, and then this is actually, when you were to click on, if you were to click on that link, this is what's going to pull up this PDF here. Okay, so one of the last things I wanted to talk through is this Form 690, which is the assurance of compliance. So an entity applying for federal financial assistance, as a condition of that application, has to submit essentially this form, that you're going to operate in compliance with Section 1557. Again, I apologize, I should have included a copy of the form there, but you can get it on the site if you go out there. And just a couple of fine points just to talk through on this. One is, if you've already submitted one of these forms, if your organization has received federal financial assistance, you don't necessarily have to complete a new one right now, but just note that if you're going to reapply at any point after July 2016, then you're going to have to complete that form. So just kind of a heads up that that's going to be out there. Okay, and then the last thing I wanted to talk through is the enforcement of Section 1557. I mentioned this earlier. OCR is the federal agency that's going to be responsible for enforcement. There are 10 regions within the OCR throughout the country. And so you just have to make sure, and there's a map out there somewhere. I'm not sure if it's on their site or if you just Google it, but you can kind of find out which particular region you're in if you're not familiar. But there are 10 different regions across the country, and it's the same group of folks that investigate HIPAA-related issues. And similar to HIPAA-related issues, or EMTALA for the hospital emergency departments, it's essentially going to be a complaint-based process. So how it typically would unfold is somebody might make a complaint either directly to them, which can happen, and then unfortunately it's sort of something that's going to come without warning, or it may be something where they did actually complain to you and you did investigate it and you did follow your policies and procedures and they still were not happy. Like I mentioned earlier, that certainly can happen. The biggest thing is you just have to make sure that you can defend and have documentation to establish that you did the best you could with your investigation. So complaint comes into the OCR. The OCR will then do an intake. They'll take down the basic information. They'll then open an investigation file, and then they'll contact you or your organization, make you aware that that a complaint was made, and then they'll give you there'll be documents they may request you to produce. They may start off with your policies and procedures, your notices, your taglines, your other things that are going to be the requirements. And then from there, it would likely get into specifics. So they may have additional document requests or additional questions they want you to answer. Potentially, they may come on site. They may interview you. They may interview other staff. And so all of this is going to be part of their investigation process or their information gathering process. And then from there, you'll receive some type of notification at the end what their findings are. And then from there, you'll determine whether or not there's going to be corrective action or not that's going to be imposed on the organization. So, all said and done, it could be a matter of a few months, or it could be, it could be a year and a half to 2 years. It just kind of depends on how complicated the situation is, what the risk is to the patients, what the risk is to the organization, those kinds of things, how involved it is. So, one thing I wanted to mention on the corrective action piece, and I didn't mention this earlier, is just the penalties part. So there aren't specific penalties within Section 1557, but what they're going to do is they're going to revert back to those underlying federal civil rights laws in terms of what the potential fines and penalties could be. So there's going to be some overlap there. But that is essentially the how the enforcement piece will work. So just some takeaways. Again, review the materials on the OCR Section 1557 site. I would say that's probably your best first step at this point if you haven't gone out to that site. As I mentioned earlier, thankfully in this particular area, they have done a lot of work for you, especially if you're like me and you're in a smaller organization where you're kind of a one-person shop for putting this information together. They thankfully have done a lot of the writing part and the content part for you. You just need to adapt it. And then I didn't put it up there, but again, I would pull off a copy of that Federal Register from earlier this year. And it's something that's probably not a bad idea to actually print a hard copy off of because it's maybe something you're going to want to have on file in case questions come up down the road. But there is a wealth of information in there related to what the OCR is thinking and how they're going to interpret these particular regulations. And then from there, ensuring meaningful access through language assistance services, whether it's providing language assistance through qualified interpreters that are on staff or through contracted services. The notice and taglines, and then designated coordinator and the grievance procedures. I didn't mention this earlier, but there are some other sample policies out on that OCR site that you would also want to consider putting in place in terms of making sure that you're providing language assistance services to LEP individuals, separate policies on not discriminating on the basis of disability, separate policies on not discriminating on the basis of sex. There are other policies out there, sample ones that you can look at and you can adopt to fit for your organization. And then conducting staff training, and then responding to issues that come up. Just make sure that you have a process in place to document questions that come up and then how you resolve those. Typically what I will do with compliance-related investigations is I'll have a file that will have my investigation notes in one section. I'll have another section that will have an actual investigation report, which is essentially includes the background, what the issue is, what my findings were, what my recommendations were if there was corrective action, and then what management did with that corrective action, if they carried it out or if they modified it. And then I would include any documentation if there was maybe retraining we had to do with a staff member and I need to get their signature and date that they reviewed the information. I would keep all that information together because then it's just nice to be able to turn that information over to the OCR if you needed to, if somebody does decide to complain to them. Because unfortunately what's going to happen is the OCR is going to investigate not only the complaint or whatever the issue is at hand, but they're also going to look at you and how did you respond to that particular grievance. So you just want to make sure your process is airtight and that you can defend what you did. And then that Form 690, if that is applicable to you, that's something that you want to make sure that you complete. And so I hope this information was helpful. Like I said, I know we're kind of at a point right now where a lot of people are trying to get up to speed with what the requirements are and trying to make sure that they're putting processes in place to be in compliance. And so I hope that this information was helpful for you. And with that, I'd take any questions that you may have.
Yeah. Thank you, Jay, for the presentation. Now we will open the lines for Q&A session. Anybody having a question button which is down. Also, you can send your questions in the chat window.
Okay, looks like we got a couple questions. Kishore?
Yeah.
First one, does the notice include the 15 taglines on the bottom? I'll answer this just a couple different ways. The actual notice from the OCR, it just includes the notice. It doesn't include the taglines at the bottom. Those are actually separate. So I'm not sure if that was the question or if it was, does your notice need to include the 15 taglines on the bottom? So in that particular instance, it's up to you if you want to include those taglines at the bottom of the notice. That's something that we did here. And it's, you know, I've seen organizations kind of do it either way. They've either had them as separate links, or they've just included everything kind of all in one document. Next question, can you confirm that interpreters on staff do not need to be certified, but can be qualified and trained in-house on HIPAA and other ethics? Yes, that's true. So they don't necessarily need to be certified, but you do need to make sure that you can demonstrate in one form or another that they are qualified. I think certification is typically the most common way that that's done, but if there's other ways you can demonstrate that they are qualified, whether it's through competency exam, or you can get maybe somebody outside the organization to essentially attest that that particular individual is qualified, then you're okay. Trained in-house on HIPAA and other ethics rules, I would definitely make sure that that's included, because you want to make sure that those individuals are sensitive to the privacy-related requirements, and then any patient consent-related issues. Then the last question, if we have a transgender patient who needs a long-term care bed, can we say no to the admission until we have a single room available? Again, I'm not specifically sure on that, on the sex-based discrimination. I just have not, unfortunately, had a chance to dive too deeply into that. But I would just encourage you to take a look through that Federal Register that's got the information out there on the different types of scenarios.
Yeah. It seems there is no questions at this moment. However, you can still send your questions to email ID at webinar@compliancekey.com. With this, we will end the session, and we appreciate your time and believe the session was informative and up to your expectation. We look forward to see in your next event. Soon you would be receiving certificate of attendance and a feedback form. Kindly send your comments. Your feedback is important for us. Thank you very much for your time and have a good day. Thank you, Jay, for the presentation.
Thank you.